Hi guys. Some guys, everyone who's seen us, who's watching us in YouTube or somewhere else. Hope you have a great day. So today we're going to talk about how to enrich your valuation by IPs and by some legal life hacks and tips. So here with us today, Tatiana, Elisa, Baseley. Yeah, is it right?
Yes, hi.
Baseley. And Olga Kunkurtsova. Nice to meet you guys. Thank you all for coming. And yeah, so we're going to talk about trends in IP and some strategies and some tips how to raise your valuation. Yeah, guys. So follow us on YouTube, follow Baseley Partners in LinkedIn, and in all social media. They're going to be in the description. So I'm going to drop the ball on the on your side, girls, and it's your time to shine. So talk a little bit about IP, talk a little bit about legal, and etc. So it would be really great to hear some good information about this topic.
Thank you very much, Emil. I think I'll make some short introduction of us. So, we are not patent attorneys in particular jurisdiction, and this defines what we do. We do general project management of intellectual property, and Olga in particular, she manages IP portfolios worldwide. So what we usually do, we do not do precise tasks, not filing for protection and so on. We develop strategies. So how we have to behave on particular territories, what we do with a particular set of intellectual property for this particular company, where we file patents, where we file for trademarks, where we protect intellectual property as commercial secrets, and what is the best way. And then we interact with local patent attorneys and patent specialists and implement this strategy. And today we would like to talk about potential strategies, what is changing in the new world, taking into account that a lot of changes going on. We can see that AI is on the rise, and software code can be copied easily, can be rewritten easily, much easier than before. And we see a lot of other things, like, for example, more tough policies of multinational corporations in protection of their intellectual properties and use of AI in preventing and identifying different breaches from their side. And they're doing sometimes crazy things. Yesterday we discussed with Olga the case of one of our clients. Facebook went for them, and Facebook asked to stop using the trademark just based on the fact that the client is using the word book in their trademark. So this was the only one similarity Facebook noticed, and they sent the infringement notice. And this is this is actually what we have now. So we have this landscape where everyone tries to compete for intellectual property, where everyone tries to be more tough, and we want to share the strategies how to behave in this realm. I will share the presentation. Emil, I can see that. Thank you very much. We want to split our presentation into 4 parts. One part is about ways to protect your intellectual property. we think this is important because what we see from software startups is that they try usually to go for the simplest way. They try sometimes only to file for trademarks protection, or they see that they have copyright for software and they only file their source code for some deposits, and they try to protect their software as copyright, which in many cases is wrong. And we will discuss in which cases the other strategies is better. The second part, we would like to talk about new things on the table. We want to talk about data. We want to talk about data scraping. We know that many companies, they use publicly available data for teaching their models, for organizing their business strategies, and so on. And there is a specific definition for this, data scraping, and there are laws and case law defining what is allowed and what is prohibited. We want to talk about rewriting of software code, because we got many questions from our clients how to change IP strategy now when AI can easily rewrite the code and even prepare beautifully written technical documentation. So it's not that difficult as before. We want to talk about trademarks and raising the value of trademarks and communities around the product. And we want to spend some time on discussing trends in trademark disputes, in patent disputes, and copyright disputes. So we start with the ways how we can protect ourselves. So here we can see that it's the best way to view your project is not to view it as a set of source codes. The best way is to look at this as technology. And when you look at your project as on technology, you can see different paths how to protect this technology. Some technologies can be patentable, and I will pass the word to Olga to discuss which algorithms, which methods are patentable, which are not, and in which cases we can choose this strategy. Some technology is better to protect as commercial secrets. And here is a very important thing for startups, because we can see that multinational companies, multinational corporations, they use this a lot. And we see this, especially in our area. We have our own software project in legal tech, and we follow legal tech disputes. And we can see that huge US and UK, American and British law firms, they protect their software as commercial secrets, because in most of the cases, legal tech software does not contain patentable technology, and they chase those who copy this and try to issue competing software on the market. So this type of protection as commercial secrets is usually not widely used among startups, but we highly recommend this. The protection as a copyright is just part of the strategy, and this is the easiest way, the most commonly used among startups, but the less, in our opinion, given the less protection. And I think at this point, I want to give the word to Olga, to you, if you can shed the light on some strategies, which algorithms, which methods are patentable, which are not, what you advise in terms of identifying patentable technology, and how you advise to build a strategy around patentability of technology. And probably you can also say something about this different ways. So when you advise to go for the route of patentability, and when you advise to go for commercial secrets route.
Okay, thank you, Elisa. Okay, when we speak about patentable technology in connection with startups, usually we speak about software and program. And a question we get asked very often, can I patent my software? And the short answer is yes, of course. Now patents can protect many types of computer software, such as mobile applications, software as a service. But when we speak about patenting software, we should remember that patenting software is not about the code. Because software code cannot be protected with a patent. Usually, as Tatiana have already mentioned, the code can be protected with copyright, but not with patent. And in this case, we also should mention that different jurisdictions may have their own opinion, their own requirements, and their own view on all process of applying and registration software as a patent. Also, when we speak about patentable technology and software, we should remember that obtaining a patent, it is a complex and time-consuming process, and not everyone too ready that it will be 3 or 2 years long, but it's the real time to protect your software. But before we discuss software as patent, I would like shortly define what a patent is and why it is important. First of all inventions and patent algorithms technology should be new, useful, not obvious in any technology field. And the second that we should keep in mind that the institution of patenting was created not to protect software. First of all, it was created to protect intellectual property in connection with processes, machines, manufacturers, or compositions of matters. And the main problems with technology and software patenting is that software doesn't technically fall into any of these mentioned categories. I mean, processes, machines, manufacturers, and so on. And according to practice, software algorithms, it's abstract. And abstract solutions in real time, according to practice, cannot be object of patenting. And in this case, we should to see on our technology, on our software from another side. And when we look at our technology of our algorithms from the another side, we should describe and to look at our software as a system and method. And this system or method should refer to the hardware or software components that work together to perform a specific task or specific steps or processes used to achieve a desired result. And when we speak about if our technology can be patentable or not, we should clearly traced the logical chain, and the logical chain looks like the purpose of invention, the purpose of software, the features of our software, and very important thing that we should achieve, it is a technical result. And the connection of the technical result with the features of our invention, of our technology, must be demonstrated to the particular patent office. For example, to determine whether your software is an abstract solution or not, in Europe, the European Patent Office applies procedures called the technical effect test. That means that the software solution must be implemented in some technical solution. Your algorithm, your technology must be implemented in some technical solution to demonstrate its technical effect and implementation. For example, if your software is used in the control of robotic machines that perform certain functions during production, it has a technical effect and implementation. And such technical effect and implementation allows us to solve the problem with the abstractness of software, of our technical solution as an independent element. And when, in this case, when we apply for patent, for protection, our software code can be like a set of direction telling a computer what functions need to be done, how to accomplish specific tasks, and what.
Алло. Алло. Алло.
Sorry, do you hear me?
Yeah, yes, Olga. Yeah.
Okay, so okay, and a software patent application needs to describe how the computer system operates with your software to achieve desired results. And your application for patent your technology should particularly explain the desired functions from the perspective of the user and the computer. And probably in the end, some of existing examples of the software patent, I can, of course, mention Facebook. Facebook has a lot of patent in technology field in connection with software and algorithms. And for example, one of the latest application, it's a dynamic mask application. And in this application, Facebook describes the software as a system and method which use social data to present users with a variety of mask options, some of which were previously selected by friends of the users, applying their masks to the user. And of course, in the this patent, we speak about some kinds of applications, some kinds of software. But as I have mentioned before, we can't put in our application source code, but we should describe how our algorithms, our technology works in connection with hardware and our physical subjects. And in this way, Facebook describes the method in the following way. The method involves using a computer to identify a person in a picture and accessing information about that person from their social media profile. Here we can see they show patent office the connection of software and computer. That means they show us that their algorithms is in connection with hardware, and that's why it will be technical effect that we can achieve on the display of our computers.
Mm-hmm.
Probably we can mention, no, also of course in application we do not put our source code, but we should show patent office and describe patent office how our methods, algorithms connecting. And in this case, usually we can find different explanation, different pictures describing on all process of connection of our software and hardware. Probably also I can mention Coinbase, the instant exchange. This is also software, and they describe the software as a system and method for transaction of Bitcoin. Also, the Coinbase doesn't put the source code in application. They just describe how it works in connection. What should we do? What should we put in our? What we should put? What kind of information we should put in our computer, and what result we will achieve when we use our software application. Probably from my side on these states, that's all.
Yes, I want to ask you a few questions just to give the guidance to the audience on some practical approaches. Like, for example, if I'm a founder of a startup company and I come to you with a description of technology, what would you expect from me to give to you? Like, for example, I'm coming to you and I'm saying that I have particular methods of organizing particular type of transactions in business communication and so on and so on. And I don't know actually where to start from. And I work in different markets. I work in the United States, I work in Latin America, and in some European countries. And what I usually need to prepare to start from?
To start from, I would like to ask you probably only 3 questions. What is the purpose of your software, of your technology?
Mm-hmm.
What is the field of use your technology? The next question will be in connection of the features. What features do you use in your technologies? What features you can describe in connections with your technology? And the last, the technical result, because without any technical result, any physical result, it will be only an abstract solution. And if it is abstract solution, we can't go to patent office to protect our technology.
I see. I want to come back to the previous picture, because what usually concerns me is how to proceed, which way of protection to use. So do I do I go to patent office and file for patent application? And actually, as a startup founder, I did it. I had this question. So I had this question when to start the process of patenting, or maybe to protect my software algorithms, methods by commercial secret. So when you would advise to go to the route of patentability, or where you would not advise this, and you just you would just tell me, just stop here and organize all documents inside your company to protect your commercial secrets?
From my point of view, if you go with your technology to the market and you will have users of your technology, of course, you should get a patent. But if you show your users only the result of your technology and they don't work with all process of your technology, probably in this case, it will be enough for you only to protect your technology by trade secret, business secret, because all process, all algorithms will be inside of your company and nobody will see how it works. They will get only the results.
Yes, I agree. I think I would add one more criteria. So if you really have a strong case on patentability, I would go for patent. And if you have some doubts or your case is not that strong, but you need to limit the use of your technology somehow, and you're going to spread your software through franchise model, for example, and you are going to share some secrets on your algorithms, on your architecture with your business partners, but your case is not that strong, so I would go to commercial secrets. So actually, this is the way we chose in our legal tech project. We chose to go so far to commercial secrets model rather than to patentability. And I think the division is not only about, like you said, going public and making visible this architecture and algorithms to the audience, but also about how strong your case is. So if case is not pretty strong, I think the publication of any information and giving it available, making it available for the audience can make worse. I also
Yes.
I also see some trends in recent cases that many companies they prefer to patent their hardware and to publish their software, so to make their software as an open software, and to give developers, our developers, the possibility to make the changes to software, to suggest the changes to software, but to protect the use of their software by protecting the hardware in which they install this software. So this also can be a strategy because if software is really visible and if everyone from looking at the software can understand the architecture and there are no hidden secrets behind this, so probably this is the good way, just to make this as an open software and to protect the hardware part. And we also met, regarding this part of our meeting, we also met some interesting questions from founders. We see that in the current situation of recession and economic turmoil, there are many startup companies where one founder burns out and leaves the company, and sometimes this is the founder who contributed in the technological part. And we can see many things, many situations where the coding of software was not paid by any shares, by any remuneration, and so on. And people are asking, what will be in this situation, which consequences will be here for the person who designed the algorithm, who created the algorithm, and who put it into this joint venture, this co-founding. And these are really tricky situations. And these are usually early stage startups when the founders did not file to any patents, and founders did not prepare any commercial secrets documentation. And this situation can be ruled in this way. So if you design something, if you created something, and if you design the algorithm and architecture of the system, and these ideas have sufficient amount of creativity in them, this is copyright, and this copyright cannot be used. So the person who just stepped out and who coded the whole process, the whole algorithm, cannot use this copyright for their own purposes. But at the same time, founder who stays with the project cannot use the code, because code, which is well written and has a particular degree of creativity, is also copyrighted. So the parties just step away with what they had initially. One founder steps away with idea and must either to pay for the code or to rewrite the code. And the founder who wrote something can either pretend and ask for remuneration if there are grounds for this, or just step away and leave this idea and do not use it for this for their own purposes. So this is also what we see on the market today. And I think we just go to another part. Yeah, before we go to another part, I just want to stop at software. And I know, Olga, that when company approaches you and asks you how to document software in a better way, usually you see and you shared it with me that you see a lot of cases when software is not properly documented. So there is a source code which is not linked to
architecture, documentation.
Yeah, and so it's not linked to any documentation, and people think that this can be protected by copyright. And I know that you have particular standards and you have particular recommendations from best practices, how to approach this. What usually you want to see for good protection?
For the good protection, of course, it is a good way when you have a documentation describing your software. And when we speak about the documentation, in documentation you should describe your software, the result, why do you create this documentation, this software, how it works, and what is the purpose of this software. On the next steps, you should describe different models of your software and how these models are connecting with each other and how it works as a one big software. In probably software documentation, you should describe how size, language, and some technical things about your software. Also, probably you should mention in your documentation
I think functions. I think the detailed
yes.
detailed description of functions is crucial. So what I saw from so I know that you supported several sales of startups through strategic investors, and what I saw from these projects is that good technical documentation is one of the key components for easy sale to strategic investor. And presence of a technical documentation when you can connect each class to the object, and you can each function can be easily seen, and how software works, and how it can be integrated into software of corporations, which is buying startup company, and how it can be changed by easily changed by corporation. This is really essential. So I know that corporations, they would expect good technical documentation and very high quality depositing of software.
Yes, of course. The technical documentation, it's important thing. But when we are speaking with technical specialists, for their technical documentation contains only symbols. But your technical documentation also should describe all processes, all connection, or all explanation how it works.
Yeah, yes, absolutely. And this is actually, so I want to share some secret. We recently talked with one big corporation regarding our own startup, and we saw the approach of corporations of technical documentation, and we saw the expectations, and expectations are quite high. So they want to see the information presented in a way that they could take this software under full control. So if you're planning your exit in a format of selling the company to corporations, it's really good way to start documenting the software at the very early stages, just to ensure that corporations, when buy this software, can integrate the software into their processes easily and can understand the software easily. So it's not only about protection, it's also about the easiness or hardship of the sale of the company to a corporation. And
probably in connection with software, the biggest advice in this case will be to create all documentation at the beginning, when you begin create your software. It will be very difficult to create documentation when you create software. I know it is not easy, but try to fix, try to do, to write, to create documentation when you developed your software.
Yes. So just to summarize this part, we have separate lines protect with technology. So first of all, view your technology as technology, not just software, and try to understand that the different routes of protecting. So you have patenting route, when you have a clear good case, when you have some unique methods, you have commercial secrets route, and this route is also very good. Usually very undervalued by startups, but it's really good not to let the ideas leak to competitors. And another route is copyright. Copyright is usually widely used by startup companies, but copyright can be tricky because copyright requires also a certain level of documenting what you have. And I go to the second part. The second part is about possibility about how AI changes the world of software now, and about different things which are going on the market. There is a thing which is called scraping of data, and oftenly we can see that people confusing data scraping and using of someone's code, someone's data. So there are two separate parts. Data scraping is what you do when you build startup around use of someone's data. We have several examples, and these are examples among our clients as well. The clients, the companies which build their software around accessing to users' data on different social media platforms, and evaluating this data and using this data for predictive analysis. This predictive analysis can be used in different merchant software, marketplace software, different selling strategies, and startups who analyze sales. We can also see it in different legal tech startups. Like, for example, in the United States, there are several startups which help to analyze profiles of members of a jury for the trial. And these companies, they go deep into analyzing the personal details which are available online. And we can see that big corporations, they behave in a way they always behave. Like, for example, Facebook and LinkedIn, they try not to let other companies to use the personal data, but we think it's probably not because they want that everyone's data be on the safe side. It's probably because they want the data to belong to them, and they try to sue companies and not to allow using this data. And there is interesting case law, and I will a little bit later I will pass the word for 5 minutes to my colleague Dmitry, who is dealing with data scraping case law a lot. And the second separate thing is using the open data and rewriting the software, or using the open data for teaching your own models to produce something. We can see that a lot of companies now build their software around ChatGPT and other large language models. Many companies, they build their startups around stable diffusion models and so on. And the things are not easy in this area as well, because we can see a lot of claims which are now raised towards companies who trained their models on the open data. Like, for example, Reddit raised some concerns about facts that OpenAI has been trained on Reddit's data. We can see that Getty Images filed the suit against a Stable Diffusion company, and their arguments are really interesting. So just very short intro into this side of the world. There is one concept which allows companies to use someone's data and not to pay for this data. The concept is called fair use, and companies like Stable Diffusion, they rely on this concept heavily. So they rely on fair use case, and they think that using open data for teaching their model, for educating their model, is the perfect example of fair use, where they do not need to pay for the license for using the images, for using the data, and so on and so on. We don't know how the practice will, in which directions the practice will go now, but we saw the arguments of Getty company, and in my opinion, the arguments are quite strong. So there is possibility that this line will develop in a situation when companies using someone's open data to train their models will need to pay standard licenses, standard license fees for the companies who own this data or which publish this data. So it's just some warning sign for companies, for startups, which connects their business strategies with OpenAI, with Stable Diffusion, and other technologies, that not everything is cleared at this point of time there. So be careful, because if these companies will be obliged to pay for license, or the use of data will be restricted somehow, it may affect the companies which build their subsequent projects on this. And here, Emil, if we have 5 minutes for Dmitry to step in and to say something about data scraping, I would ask Dmitry to do this. Yeah,
sure.
Okay. Perfect. So I'm opening the table with latest data scraping cases. Data scraping cases. Yeah, here it is. Here it is, and yeah, I will open the table. Yes, here it is. Can you see the table?
Yeah.
Yeah.
Yes, and I'll give my seat to Dmitry to go through this table and to tell the world what we should know about data scraping in case law.
Hello, everyone. Glad to see everyone who I know and who I don't know yet. Thank you for passing to me the word. So the topic and the topic of data scraping is very hot, because it's a quite known situation that many companies nowadays using AI, and therefore they need data, because data is like a is like a food for AI, and they need to train the AI, and therefore they have to do so-called scraping of others' data, not their own data. And there is a very controversial question: is it lawful or not lawful? So, what is the definition of data scraping? During the course of our study of the data scraping law, we have let's say labeled a lot of languages that common law judges use to define this conduct. And we made such interactive table, which is shared on the screen, which give a sense what is data scraping today. It's not only like one law or two laws, it's a bunch of laws. For example, and primarily, as you know, common law is just case-by-case basis. The basic case, which gave a so-called new direction, new wave into the data scraping classification, is Van Buren case of police officer Van Buren, who gained unauthorized access to the internal database, and then he got sued. But then later Supreme Court said it was not a violation of criminal law, it was just a very good authorized access. So based on that case Van Buren, later, already let's get closer to data scraping, in the more widely known case, HiQ with LinkedIn, the Court of Appeal, which is also a very authoritative court in the United States, have found that HiQ Lab, the company which does data scraping, did not violate Computer Fraud and Abuse Act by scraping LinkedIn's data. And in this case, HiQ with LinkedIn, if I go to this interactive link and now interactive table, I hope that you also can see my screen. There is the judge, thanks to the judge in this case, he just made a review, a very good review, what is data scraping and particular unauthorized access and what is not unauthorized access. So I am several times was asked why Facebook was successful in suing the data scrapers and LinkedIn was not successful in scraping in suing the data scrapers. The answer looks like come from a case HiQ with LinkedIn itself. For example, there is a line, a standard which defines what is unauthorized access. For example, in Facebook with LinkedIn, the company Facebook managed to prove that there was a breach of security. You can see here on my screen. With the yellow color, it is labeled or highlighted the particular language which described what is the standard of how to convict the data scraping in Criminal Computer Fraud and Abuse Act. Because Power Ventures, here the data scraper, was gathering user data that was protected by Facebook username and password authentication system. But the data HiQ was scraping was just available to anyone with a web browser. So that's why the standard established in all common law case law now for data scraping is not a breach of contract. It's not a standard nowadays, but the breach of security only, which means the breach of password protection. So this is just a very common sense what is data scraping today and what is not, which is more importantly, what is not breach of Computer Fraud and Abuse Act by data scraping today. That's it. So if you have any more questions, I can do like a 30-minute seminar later, but 5 minutes is over. Thank you. If you have any question, I also can answer, by the way.
Thank you, Dmitry. If you guys have any questions, you can just open your mic or maybe just drop a question in the chat and I'll just pronounce it and spell it, yeah. If no, we can drop a ball on the side, or we can just give some couple extra minutes to Dmitry if he have some extra info or a freestyle idea or something else. We can just go, you know, random.
Yeah, if you have questions, please share with me. Meanwhile, I will continue talking about what is data scraping, what is not. For example, data scrapers can be convicted not only with violation of Computer Fraud and Abuse Act, which is a criminal statute, but also they can be convicted by the companies who want to protect themselves against the data scraping with, for example, different law, not only CFAA, but breach of trademarks. This is also well known, not for me personally, but for lawyers, let's say so, who deal with this many years. the so-called trespass or like breaking some property. It maybe sounds very strange, but breaking the property is also very good related to data scraping. For example, the company, well-known company Intel, it was not nowadays, it was like in 2003, so well times, let's say so ago, it managed to bring a case against the former employee, and it was not against data scraping, but it was very similar. It was a trespass to chattels, means damaging the things belonging to Intel, means the servers, the computers, and etc. But they was not successful because the damages was not proved. There were no actual damage. It's again a case of a mere use without any substantial damage to company. So it's again was not unauthorized access, means was not in that terms data scraping, was not data scraping as well. So also other companies, like in case Nozzle in some other year, tried to convict the data scraper in violations of duty of loyalty. But the court said that violation of duty of loyalty, maybe it's kind of breaking the law as well, but violation of duty of loyalty or agency duties is not a breach of criminal statute. So if data scraper scrapes the data, he's not or he not is not a criminal. Maybe there is a violation of contract, but it's another story. And just to summarize, if you want a very strict line, what is and what is not data scraping, the line may be given maybe drawn like here. If access is limited to one or more individuals, then it could be potentially a data scraping because access is limited. But it was initially at the first place free access, but later there was a banning of one or more individuals, then it's not data scraping. I hope I did not overwhelm you with those definitions. And yeah, how do I know all that? Because from time to time, with our mighty team of lawyers, we just take out one of the cases and once a week we label them and find new language, what is data scraping, what is not, but it's not the only activity what we do, of course, because we do labeling of many cases. But this topic of data scraping we label as well to know what it is.
All right, Dmitry, thanks a lot. If you're gonna have questions, I'm gonna hit you up in DMs, or I'm just gonna ask Tatiana to invite you back again. Thanks a lot. Olga, dropping a word to you.
Yes, and I'm coming back as well. So you can see there are a lot of interesting concepts which are not really visible to startup founders. And when we start the company, we can think that intellectual property is not the hardest topic. So the hardest topic is business, but not all these things around software. And we can simply do our work, design algorithms, code something. But this is this is not really easy from the standpoint of legislation. So when we design something, we can occasionally breach someone's patent and can be prohibited from entering the markets. When we design something, we can occasionally get some unauthorized access to the data and then be prohibited from entering into the market based on this ground. We can breach someone's copyright. Some companies, if we, for example, had relations with PAM as franchisee or business partner, can claim that we had access to their commercial secrets. So there are a lot of areas we need to watch very, very carefully on our way to develop technology and to bring this technology to the market. And we have 2 more chapters, but they are much shorter than previous chapters. One chapter is about trademarks, And here I will pass the word to Olga, but I think we will give some short summary to the audience about really substantial cases for trademarks. I can see from my experience and from my communication with businesses that trademarks are on the rise again. I saw several years ago the trend that companies did not just stop caring too much about trademarks. And we saw some of the cases, like, for example, case with Miro, when companies entered the market with one trade name, and they just didn't file for protection. They lost the name, they changed the name, they gained the audience under the another name easily. But now I see very high activity in building the community around the product, and I can see that this community building becomes a very substantial element of business strategy for many companies. And once the community comes to the stage, the importance of recognizing the trade name of a company also comes to a stage. And what I can see, but it may be subjective, maybe you can, maybe you give another comments, maybe you have different view, but my subjective feelings, what I see from my experience is that people started caring about trademarks more than several years before, just because the power of community becomes stronger, and the people care about recognition of their trademark more. So this is my subjective thoughts, and I would love to hear your thoughts and your opinion on this.
Okay, from my point of view, I would like to say that now there are two main ways how to protect your trademark. One way is an official way to get a registration of your trademark in intellectual property offices, and another way to protect your trademark to use some kinds like common law trademark. It's unusual way, but this way exists, and sometimes if you want to, if we don't want to spend our money on trademarks on special territories, we can use this institute. And the common law trademark is a type of protection that arises not from registration your trademark, that arises from the use of a particular mark in commerce in particular territory. But also it is very important to mention that this institute doesn't work worldwide. It works only on particular territory, such as United States, Canada, United Kingdom, New Zealand, and as far as I remember, Australia. It's a good way when you don't want to spend a lot of money to protect your trademark, but from another side of this issue, it will be of course good when you go to intellectual property office and apply and get your protection and registration your trademark. And probably I would like only shortly say about some steps when you think about creation of trademark, protection of trademark, and so on. When you buy or create your trademark, the important things that you should be very carefully when you create it, because national legislation have some requirements how your trademark can or cannot looks like. For example, you should avoid generic terms in your trademark. It's obviously that you can't choose trademark chair when you sell chairs. You can't use some descriptive terms, such as, for example, when you sell chocolate, you can't use trademark with the word sweet, and so on. Also, when you create or probably buy trademark, you also should keep in mind that probably there is another trademark already exists on the market. And you always, before you go to intellectual property office, should check whether something similar or identical exists. And another main step and thing about which you should think carefully, it's a territory of protection. You should remember that trademark is protected only on the territory where you got a registration certificate. For example, if you have a protection on US territory, it doesn't mean that somebody can't register the similar trademark in European Union. And also, please, when you thinking about trademark, be carefully which goods and services you would like to protect under your trademark. It's very important to be carefully and choose only particular things that you really produce or really your services connect with. And of course, when you already have your protect and registration, remember that you should use your trademark because sometimes if you do not use a trademark, your registration can be cancelled. This institute doesn't work worldwide. It depends on national requirements, but you should remember that if you have a trademark, you should use it. If you don't use it, it may be cancelled.
This is actually well, I didn't know about this, and it was interesting that I learned it from you that when you start getting claims from other companies, that other companies can use this argument against you, that your trademark was not used on a particular territory, and therefore it shall be cancelled there so that they could use their trademarks. This was really interesting point for me.
Yes.
So I felt that once it is registered, it is mine, and I can use it during the term they granted the protection to me.
And in this connection, you should always remember that there are a lot of difference in national legislation in connection of using and registration trademark. For example, in European Union, when you register your trademark, you should apply for all classes, and you should not to give to intellectual property office some evidence if you use or don't use your trademark, but only when you don't use, somebody can go to patent office and try to cancel it. For example, another situation in United States. In United States, when you apply for trademark registration, you should show patent office if you really use your trademark in connection with goods and services which you mentioned in your application. And sometimes it's difficult to provide patent office real evidence of using your trademark, but there are in United States, there is a institute like intent to use. You can apply without any evidence, but you have time, and during this time you should to send to patent office evidence when you begin use this trademark connection goods and services.
I know I know another trick from you, which I really want you to share with the audience. I remember that one day I approached you and I asked why we do not use in that particular case the pan-European registration of a trademark. So why we chose the strategy to register the trademark in particular countries. And I know that, for example, many platforms which automate application for trademarks, they use this pan-European application, which is easy to automate, and they do not use this per country application. But in some cases, you advise not to go to pan-European application, but to go to per country application. And when do you advise this?
Okay. When we speak about European Union and the strategy how to use a particular office where we can, where we should apply our application, in every case we should check the trademark if whether any similar trademark exists. And in this case, we should resolve how it will work and in which way we should go. Probably this will be the answer.
I see. So yes, I remember the case that you told me that there is a high probability that that particular trademark looks quite similar to already registered trademarks in particular countries. And if we would go to pan-European registration based on similarity of these trademarks, trademark with particular trademarks in particular countries, we would get the rejection for application in total. But if we would go to registration per country, we would ensure our protection, at least in particular countries where we had no this issue of similarity. Yeah, I see. And I remember another trick from you regarding this chapter is a trick about classes. And I saw the disputes you handled for marketplaces. And I saw this interesting case when software marketplaces, they register their trademarks only in particular classes. So they register them as software, but they do not use the class of goods or services they offer on their marketplace. And I know that you're currently managing the case for where this particular issue arises when the marketplace registered the trademark only for the class of software, but did not do it for transportation, and got declines from transporting companies which had similar trademarks. And they said that in that particular class, trademark belongs to us, so you cannot simply offer transportation through your website, because transportation is covered by our trademark. So this is another tricky thing which I learned from your cases, and it's really interesting.
Yes, it's really interesting, and the question is the money. If you have a lot of money, you can cover a lot of classes. You can cover 9 classes in connection with software, mobile application, and so on. And you can file your application in 42 classes, your software as a service. And in this way, you cover your software, your product. But if you have enough money, you can go, you can make one step, and you can protect your software in connection of the services which customers and users can buy on your platform. For example, if you only marketplace, but your marketplace work in real estate, you can apply for trademark connection services in real estate. But really, you understand that you don't provide any services in real estate. You work just only marketplace. For example, if your platform is platform for beauty specialist, you can apply for also in some classes in connection with beauty services and so on. And it's interesting and difficult questions, and always depends if you have enough money. Of course, we can recommend you to apply and protect your trademark in your specific classes in connection with your software, your application, your services as your software as a services, and so on. But also we recommended to protect your trademark connection with services which can users find on your platform.
It makes sense, actually. So if I'm thinking from the side of startup founder, I probably would rather limit the territories of application, just leaving the territories which I go in 5 years, in 7 years aside, and concentrating on the territories which I am answering now, but expanding the classes of applications. So for me personally, I would choose this strategy, because I definitely do not want to get declined from someone who filed the application for this trademark in that particular class. Like, for example, we have this legal tech startup, and if we file protection for marketplace or for software, but we do not file protection for advisory services, and we do not have this degree of recognition to get the protection based on recognition by the audience, someone can easily just cut us off from the market based on registration in advisory class, and saying that we cannot offer through our marketplace any advisory support to our clients, because it's covered by different trademark and different in the activity they are assigned to. Yes,
you're absolutely true. But in this case, I also want to mention one thing, that your product, your services is constantly developed. And in this case, when your product was changed, you changed your services, you should change your trademark, your services and goods which cover by your trademark. Probably during the time you will change and how your trademark looks like. And this is also things that you also should keep in mind and do it in a time.
Yeah, yes, I agree. I agree. And we approach into the last chapter of our today's discussions. This chapter is about disputes and trends. This is actually a huge chapter because there are a lot of cases going on right now, but we will limit it to some cases from our practice and some secrets we want to share. So again, from my subjective experience, what I see from disputes that there are disputes around trade secrets. There are disputes in legal tech industry, which is of particular interest for me. And I can see that big law firms, they chase smaller legal tech firms based on this allegation that these big law firms had particular trade secrets, and small legal tech companies, they just use these trade secrets, obtaining this information somehow from links with these big law firms. I can see disputes around trademarks, and I see that multinational corporations, they are very, very active in this. I think it's because of technical possibilities to chase the use of trademark and the words and elements the trademark consists of. So the technical possibilities are much better now. So you can simply put on a track elements you want to track, and to file automatically infringement notice to everyone, to everyone who, according to software, this tracking software uses the elements. So we see many infringement clients from big corporations, and these clients cannot just be set aside. Startup companies, they need to handle these clients. And regarding copyright protection, I don't know, Olga, maybe you have different observations, but I can see that I can see less copyright disputes than before. So I can see more trade secret disputes, more trademark disputes, and more disputes around data and who has rights to use this data and to whom they belong.
Probably I agree with you that there are a lot of disputes around trademarks. Probably before it is my, because trademarks, it is my main field for practice. But I think that copyright disputes also exist, but there is no a lot of disputes in connection with copyrights in my practice.
And I know that Max asked me before, what is the average price for the dispute? So how startup can handle this, and what we can expect. So I can tell from my side that what we can expect as a startup company, we can expect many things. Like I mentioned before, if we use someone's data to teach our model, to use it in a business strategy, we can expect data scraping claim from a platform where we get this data. If we an AI project and we use the data which are not sold to us based on a contract, like I know that many biotech companies and especially biotech companies, they teach their models and they do research based on data they bought from clinics, they bought from someone, so they legally own the data they use for analysis. But many AI, generative AI companies, they didn't buy this data. And if you buy this data, you can say that you use them legally. But if you do not buy this data, if you use open data, you can expect the claim from the platform where this data were published. Patent claims. Again, I mentioned before that when you create technology, it can look like this is your idea, and you have full rights to implement this idea and to create something based on this idea. But this idea can be not idea. The method which is contained in this idea may be already patented somewhere. So it's really good. It's really good idea to check, to make this basic patent search, whether the thing you are going to create has any patent protection or not, just to avoid the waste of time when you develop something and you simply cannot enter the market with this thing. Trade secrets, yes, so watch out for classes you register your trademarks, for territories, domain disputes. Just make sure that if you register a domain name, you have respective trademark correlated with this trade name, with this domain name, because if someone owes the trademark and the domain name is similar to this trademark, you can get the claim for this. And regarding cost of protection, Olga, so we discussed it before, and as I understand, in Europe it's not quite high. Depending on how you define not quite high. So in Europe, I know that some disputes can cost the company something around 2,000–3,000 euros, and some heavy disputes can cost around 30,000 euros. And this is not the same case with the United States, and not the same case with many different jurisdictions. Like, for example, if you are going to dispute in Hong Kong or Singapore, it will be quite high because of high legal costs. If you go to dispute in China, it's probably also be quite high price because of high legal costs. But in Europe, the costs are quite moderate because attorneys' fees are quite moderate, stamp duties are quite moderate. So the best jurisdiction for small startup company to go through legal dispute, as I understand correctly, is Europe. Is it right?
Yes, you're absolutely right. And just like summarizing, the cost of protection, the cost of dispute will depend on several things. First of all, territory. As you have mentioned, probably United States will be one of the high cost jurisdiction.
I think UK as well. And
yes, UK. And the second things, it's type of IP, intellectual property, because of course patent disputes, it's one of will be cost more than disputes in connection with trademarks or trade secrets, probably.
Yeah, thank you. Thank you very much. And I want to summarize these disputes again by things we need to take care of. So yes, when we develop technology, I know that I mentioned this before, but this is really, really important. When we develop technology, so we do not need to rely on the idea that if it came to our mind, so this is our idea and this is free and we can start developing something. So it's really good to make some patent search and to find who can attack us in which jurisdictions by their patents, saying that this technology has been already protected and we cannot do the same. If we use data, so we better use them carefully and to understand carefully whether we need to pay for this data and do we have open license to use this data. And if we use this data openly, do we have obligation to keep this data, to keep this software as open source software, which is often the case. And same is about not only data, but also about third-party software, because there are a lot of open source software which are used during the process you build your startup, and many licenses, they are given free if you give your software to the audience free as well. So if you build open source software and you do not charge anything for use of your software, use of this free licenses is possible. If you're going to issue commercial software and to charge the customers with something for this software, it's better to change the license and to buy the rights to use particular data, particular information, particular software, particular source data, not to be restricted from monetization. So this is mostly all. The topic again is very, very broad, and we tried to give highlights on whole area of intellectual property, what you can expect when you step into this area, and we tried to highlight as much subjects as possible, that just to give you directions. Which issues you will need to handle when you develop your company. So this is actually all from our side, and we will be happy to answer the questions.
Thank you, Tatiana and Olga, for this interesting journey for us, and the whole bunch of this information that is pretty new for us. Yeah, guys, and if you have any questions, you can just open your mic and ask them, or you can just drop the message to the chat. If there is no, we will release this video in our YouTube channel, and we're going to drop it to our community, to all of our startups. We have more than 1,000 startups in our pipeline, and to all of our partners. So we're going to collect these questions, and on Friday, we probably gonna have a meeting with our founders in the Zoom. So Tatiana and Olga are gonna be invited as well, and we can drop a lot of questions and make a Q&A session on this complicated topic. So if you're watching this record, join us in Zoom on Friday. And I see Max have opened the camera. Is it about the question or just an accident?
Yeah, I told only that I pledged our meeting today.
Right. So as I see, there is no questions in the chat, and I see no open mics. I'm gonna close the recording.